Madam President.
Senator from Rhode Island.
Thank you, Madam President. The Attorney General of the United States holds a vital and also somewhat unique position in the federal government. The Attorney General of the United States is tasked with significant responsibilities that must be executed independently, sometimes even in defiance of the White House's wishes and interests. The Attorney General of the United States is tasked with enforcing our laws fairly, justly, and even-handedly, as well as with protecting the civil and constitutional rights of all Americans, of all persuasions, of all backgrounds. The Attorney General of the United States does not work for the President so much as for the people, and does not serve the administration so much as the law. I have served in the United States Department of Justice. I have felt its esprit de corps, its pride. And that pride is founded on a firm sense of the department's willingness to stand on what is right, even against the wishes of the White House. One fine example of this was Attorney General Ashcroft challenging and refusing to accede to the wishes of the White House on the Bush administration's warrantless wiretapping of Americans. The Department of Justice is well aware of the importance of its independence, and a successful Attorney General must be stalwart in protecting the department from political meddling by the administration or by Congress. We need only look back to Attorney General Gonzalez's resignation to recall how badly things turn out when an Attorney General yields to political pressure. An Attorney General also makes policy decisions about where and how to direct the department's $27 billion budget, and when and how to advise Congress to recommend new laws and modify existing policies. These are policy choices an Attorney General makes. It is no answer to questions about those policy choices to say, I will follow the law. That doesn't apply in this arena of funding decisions and legislative recommendations that are policy choices, not dictated by law. And those policy choices can have a profound effect on individuals, on communities, and on the fabric of our nations. Americans should be able to trust that their Attorney General will not only enforce the laws with integrity and impartiality, but stand up for Americans of all stripes and fight on behalf of their rights. That is the prism through which I evaluate Senator Sessions' nomination. I have known Senator Sessions for a decade and have enjoyed working with him on a number of pieces of legislation. However, the standard by which I evaluate an Attorney General nominee is whether Rhode Islanders will trust that in the tough clinches, he will be always independent and always fair. I have reviewed Senator Sessions' career as an attorney and as a senator, as well as his testimony before the Judiciary Committee. I have reflected on my own duties and experience as my state's Attorney General and as the United States Attorney in Rhode Island. I've also served as an attorney in our state Attorney General's office. And by the way, the Attorney General in Rhode Island has full prosecutive authority. Many states have a division in which the Attorney General has a narrow ambit of authority and district attorneys do the bulk of the criminal prosecution. Not so in Rhode Island. I've also had the occasion to listen closely to very strong and honest, serious concerns from Rhode Islanders who have made it plain to me that they fear what Senator Sessions would do as head of the Justice Department. For every constituent of mine who has expressed support of his nomination, 15 have expressed opposition. Senator Sessions has fought against fixing our immigration system, opposing, indeed, as the leading opponent of bipartisan legislation, which, had it passed, would have spared us much of the current debate over walls and immigration. Senator Sessions fought against our bipartisan criminal justice and sentencing reform bill. Senator Sessions opposed reauthorizing the Violence Against Women Act, a bill which is vitally important to the Rhode Island Department of Attorney General and to the anti-domestic violence groups around Rhode Island. Senator Sessions' record on support of gay and lesbian Americans has alarmed many Rhode Islanders. Public statements and confirmation testimony by Senator Sessions suggest that he brings a religious preference to the department and that what he calls secular attorneys would be to him suspect compared to Christian attorneys. That distinction between a secular attorney and a religious attorney is one that runs counter to very solid principles upon which my state was founded. Roger Williams brought to us freedom of conscience. Senator Sessions has called Breitbart News a bright spot. I must disagree. Breitbart News is not to me a bright spot. Breitbart has published baseless and inflammatory articles with titles like "Birth Control Makes Women Unattractive and Crazy." In fairness, I should disclose that Senator Sessions' nomination carries an additional burden with me as the nominee of this president and this White House. The need for an independent attorney general has rarely, if ever, been greater. On the campaign trail, the American people witnessed Donald Trump glorify sexual misconduct, mock a disabled reporter, and make disparaging remarks about immigrants and minorities. We all witnessed chants at Trump rallies of "lock her up." At his confirmation hearing, Senator Sessions excused these as, and I quote him here, "humorously done." But in mass rallies that also featured people getting beaten and the press caged and vilified, this didn't seem very humorous to many Americans. I think Americans know that the good guys in the movie are not the ones in the mob. The good guy is the lawman who stands on the jailhouse porch and sends the mob home. That lock her up chant, to me, was un-American. And I believe across the country it made honest prosecutors' stomachs turn. Not surprisingly, many Americans are fearful of what the Trump administration will mean for them, for their families, and for their country. The problems with this president did not end with the campaign. President Trump and his family have brought more conflicts of interest to the White House than all other modern presidents and families combined. The proposed Trump domestic cabinet is an unprecedented swamp of conflicts of interest, failures of disclosure and divestment, and dark money secrets. We have not even been permitted in the course of our nomination, advice, and consent process to explore the full depths of that unprecedented swamp, because the dark money operations of nominees have been kept from us. And in one case, thousands of emails are still covered up. The Trump White House traffics in alternate facts, operates vindictively, and is a haven for special interest influence. None of this is good. All of this suggests that there will be more or less constant occasion for investigation and even prosecution of this administration. Independence is at a premium. Nothing could have made this more clear than the first disagreement between the Trump White House and the Department of Justice, whose outcome was that the acting Attorney General, a woman of 30 years' experience in the department, a career prosecutor, former Assistant United States Attorney, former United States Attorney, and someone recognized for her leadership throughout the department, was summarily fired. This is also not a good sign. In recent history, Attorneys General Gonzalez, Meese, and Mitchell were politically close to their presidents, and the Gonzalez, Meese, and Mitchell tenures did not end well. Attorney General Mitchell worked for President Nixon. They met when their New York law firms merged in the early 1960s, and they became law partners. John Mitchell was the campaign manager for Nixon's 1968 presidential campaign. There were signs that things weren't quite right, because when Nixon nominated Mitchell to be his Attorney General, he appealed directly to FBI Director Hoover not to conduct the usual background check. Mitchell ultimately resigned as Attorney General in order to run President Nixon's re-election campaign. So the political link between Mitchell and Nixon was very close. And sure enough, scandal ensued. Attorney General Mitchell turned out to be a central figure of the Watergate scandal. As the chairman of the re-election committee, the famous CREEP, Mitchell was responsible for appointing G. Gordon Liddy and approving the Dirty Tricks program while still Attorney General. That Dirty Tricks program ultimately included breaking into Democratic National Headquarters in the Watergate. The upshot of this was that Mitchell was charged with conspiracy, obstruction of justice, and 3 counts of perjury. He was convicted on all counts, and he served 19 months in prison. Attorney General Edwin Meese was also very close to President Reagan. Meese joined the 1980 Reagan presidential campaign as chief of staff. He ran day-to-day campaign operations and was the senior issues advisor. After the election, Edwin Meese was given the job of leading the Reagan transition. And once in office, Reagan appointed Meese as counselor to the president. According to press accounts at the time, Meese was known as someone who, quote, has known the president so long and so well, he's become almost an alter ego of Ronald Reagan. That was the political background between Meese and President Reagan. Again, it did not end well. Meese came under scrutiny for his role in the Iran-Contra scandal. The congressional committee that reported on the Iran-Contra scandal in November 1987 determined that Meese had failed to take appropriate steps to prevent members of the administration from destroying critical evidence. An independent counsel named Lawrence Walsh finished a report in 1993 that stated that Meese had made a false statement when he said that Reagan had not known about the 1985 Iran-Contra deal. Iran-Contra was not the only controversy that plagued Attorney General Meese. A company called WedTech Corporation was seeking Department of Defense contracts in the early 1980s. The company hired Meese's former law school classmate and his personal attorney, a lawyer named E. Robert Wallach, to lobby the Reagan administration on its behalf. Attorney General Meese helped WedTech, at Wallach's urging, get a special hearing on a $32 million Army engine contract, although the Army considered the company unqualified. Well, the contract was awarded to WedTech, and then one of Meese's top deputies went to work for WedTech. The federal criminal investigation that resulted led to the conviction of E. Robert Wallach, the former law school classmate and personal attorney of Meese, for whom he had set up the meetings with the government. Independent counsel James McKay investigated the WedTech contract, including investigating allegations of misconduct by Meese. While Meese was never convicted, he resigned following the issuance of the independent counsel's 800-page report. Third is Attorney General Gonzalez. Attorney General Gonzalez was close to then Governor Bush in Texas. He was his general counsel. When Governor Bush became President Bush, Gonzalez came to Washington to serve as Whitehouse counsel. He was appointed Attorney General in 2005. During his tenure at the Department of Justice, there were multiple investigations, many of which played out before the Senate Judiciary Committee, involving the warrantless wiretapping program, the U.S. Attorney's scandal, and inquiries into the department's management of the torture program legal opinions. Ultimately, members of both houses of Congress called for Attorney General Gonzalez's resignation or demanded that he be fired by the president, and Attorney General Gonzalez resigned. There is a track record here of attorneys general who are politically close to a president coming in harm's way and doing poorly in the department. One particular office that is vulnerable to this kind of undue proximity and failure of independence is a body in the Department of Justice called the Office of Legal Counsel. Jack Goldsmith, a former head of the Office of Legal Counsel, and a Republican, by the way, testified before the Senate Judiciary Committee that, and I'll quote him here, more than any other institution inside the executive branch, OLC is supposed to provide detached, apolitical legal advice, and it has an honorable tradition of providing such advice to a remarkable degree. But under the Bush administration, the OLC departed from that tradition. It came up in a number of ways. The first was during our investigation into President Bush's warrantless wiretapping program, when Office of Legal Counsel memos supporting the program came to light. I plowed through a fat stack of those classified opinions that were held in secret over at the White House and pressed to have some of the statements declassified. Here are some of the statements that were declassified, found in those OLC opinions. I quote, "An executive order cannot limit a president. There is no constitutional requirement for a president to issue a new executive order whenever he wishes to depart from the terms of a previous executive order." So this means that a president could issue an executive order, have it published in the Federal Register, put it forward as the policy of the administration, a direction to all the attorneys in the administration, and then secretly depart from it without ever changing what the public is told about the policy. A theory like this allows the Federal Register, where these executive orders are assembled, to become a screen of falsehood behind which illegal programs can operate in violation of the very executive order that purports to control the executive branch. That was just one. Another one, I'll quote, "The president, exercising his constitutional authority under Article 2, can determine whether an action is a lawful exercise of the president's authority under Article 2. If that sounds a little bit like pulling yourself up by your own bootstraps, well, it sounds that way to me too. And it runs contrary to a fairly basic constitutional principle announced in the famous case of Marbury versus Madison, which every law student knows, which says it is emphatically the province and duty of the judiciary to say what the law is. A third example, and this is another quote from an OLC opinion, the Department of Justice is bound by the president's legal opinions. Well, if that is true, what is the point of a president sending matters over to the Department of Justice for legal review? If the president did it and it's therefore automatically legal, there would be no function to the Department of Justice accomplishing that legal review. So in this area of warrantless wiretapping, the Office of Legal Counsel within the Department of Justice came up with what seemed to be quite remarkable theories in the privacy and secrecy of that office, in those classified opinions, that are really hard to justify in the broad light of day. That's why independence matters so much. Obviously, the White House wanted those opinions to say what they said, but in the clear light of day, they don't hold up. Let's move on from the warrantless wiretapping opinions of the Bush Department of Justice to the OLC opinions that the Bush administration used to authorize waterboarding of detainees. Again, I was one of the first senators to review the OLC opinions. And when I read them, I will say I was quite surprised. I was surprised not just by what they said, but by what they didn't say. One thing that was entirely omitted was the history of waterboarding. Waterboarding was used by the Spanish Inquisition, by the Khmer Rouge in Cambodia, by the French suppressing revolts in Algeria, by the Japanese in World War II, and by military dictatorships in Latin America. The technique, as we know, ordinarily involves strapping a captive in a reclining position, heels overhead, putting a cloth over his face, and pouring water over the cloth to create the impression of drowning. Senator John McCain, held captive for more than 5 years by the North Vietnamese, said this of waterboarding: "It is not a complicated procedure. It is torture." End quote. American prosecutors and American judges in military tribunals after World War II prosecuted Japanese soldiers for war crimes, for torture, on the evidence of their waterboarding American prisoners of war. None of that history appeared in the Office of Legal Counsel opinion. The other major thing the Office of Legal Counsel overlooked was a case involving a Texas sheriff who was prosecuted as a criminal for waterboarding prisoners in 1984. Let's start with the fact that this was a case that was brought by the Department of Justice. It was the United States Attorney for that district who prosecuted the sheriff. The Department of Justice won the case at trial, and the case went up on appeal to the United States Court of Appeals for the Fifth Circuit, the court one level below the United States Supreme Court. In its appellate decision, the United States Court of Appeals for the Fifth Circuit described the technique as, and I quote, water torture. All a legal researcher had to do was to type the words water and torture into the legal search engines Lexis or Westlaw, and this case would come up. United States versus Lee. You can find it at 74 F. 2nd, 1124. Over and over in that published appellate opinion by the second highest level of court in the federal judiciary, they described the technique as torture. And yet, the Office of Legal Counsel never mentioned this case in their decision. Ordinarily, what a proper lawyer is supposed to do, if they find adverse precedent, i.e. decisions that appear to come down a different way than the argument that the lawyer is making, is that you report the decision to the court and then you try to distinguish it. You try to convince the judge you are before why that case was either wrongly decided or doesn't apply on the facts of your case. But the Office of Legal Counsel didn't offer any effort to distinguish the Fifth Circuit decision. It simply pretended it didn't exist. Or it never found it. It's hard to know which is worse. At sentencing in the Lee case, the district judge admonished the former sheriff who had been found guilty of waterboarding. The operation down there would embarrass the dictator of a country. Well, it's also pretty embarrassing when what is supposed to be the institution inside the executive branch that is supposed to provide detached, apolitical legal advice in an honorable tradition of providing such advice to a remarkable degree, to quote Professor Goldsmith, misses a case so clearly on point. That wasn't the only OLC error. In addition to the warrantless wiretapping statements, in addition to the Office of Legal Counsel opinions on waterboarding, they undertook a review of the Foreign Intelligence Surveillance Act. In the Foreign Intelligence Surveillance Act is something called an exclusivity provision. It says this: the Foreign Intelligence Surveillance Act, I quote, shall be the exclusive means by which electronic surveillance and the interception of domestic wire, oral, and electronic communications may be conducted. Shall be the exclusive means. Seems pretty clear, but the Office of Legal Counsel said about that language, I quote them here, unless Congress made a clear statement in the Foreign Intelligence Surveillance Act that it sought to restrict presidential authority to conduct wireless searches in the national security area, which it has not, then the statute must be construed to avoid such a reading. Which it has not? Congress said that this shall be the exclusive means. And if the OLC wasn't happy reading the language of the statute, they could go to a court where this language had already been construed. The decision was called United States versus Andonian, and the judge in that case ruled that this language, the exclusivity clause, I'm quoting the court's decision, reveals that Congress intended to sew up the perceived loopholes through which the president had been able to avoid the warrant requirement. The exclusivity clause makes it impossible for the president to opt out of the legislative scheme by retreating to his inherent executive sovereignty over foreign affairs. The exclusivity clause assures that the president cannot avoid Congress's limitations by resorting to inherent powers. So, in the face of that case law, the Office of Legal Counsel held that Congress hadn't said what it said, and this was not exclusive language, even though a court had said so. So the reason I share those three stories is because it really matters in important issues when the Department of Justice has the capability and the courage to stand up to the president. And it really matters when they get it wrong. It really matters when they say things that simply are not correct or legally sound in order to support a warrantless wiretapping program. It really matters when they don't find the case on point to evaluate whether waterboarding is torture. It really matters when they go around a clear congressional statute which a judge has said closes the door to going around that statute by simply saying privately, well, that door is not actually closed. It matters. I have insufficient confidence that as Attorney General, Senator Sessions will be able to stand up to the kind of pressure we can expect this White House to bring. We know that this White House operates vindictively and likes to push people around. We found out recently that Mr. Bannon went running over to see General Kelly to tell him to undo the green card waiver of the Muslim ban. Thankfully, General Kelly refused and stuck by his duty. But this is the kind of White House we have, where they try to push people around to do the wrong thing. They're so contemptuous of authority outside their own that they're willing to attack a federal judge who disagrees with them, calling him a so-called judge. They're willing to fire an acting attorney general who disagrees with them, firing her summarily and accusing her of betrayal. The pressure that this White House can be expected to bring on the Department of Justice to conform itself not to the law, but to the political demands of the president is going to be intense. Moreover, the conflicts of interest that crawl through this White House and that crawl over this swamp cabinet offer every reasonable cause to believe that there will have to be investigations and prosecutions into this administration. That combination of a target-rich environment in this administration for investigation and prosecution with a vindictive White House that does not hesitate to try to bully officials into conformity calls for the highest degree of independence. And I don't feel Senator Sessions makes that standard. He was too close to the president during the political race. He has not stood up against any of these excesses that I have mentioned since then, and it is with regret that I must say I will not be able to vote to confirm him. One of the reasons I became a lawyer was because of To Kill a Mockingbird. As a kid, I just loved Atticus Finch. He's great in the movie. He's even better in the book. Some of the things that Atticus Finch says about the law and about human nature are so brave and so profound that from the first time I read that book, boy, I would have loved to have been Atticus Finch. Would have loved to have the chance to stand in the breach when everybody was against you and stick up for doing something that was right. Gosh, that felt so great. And like the scene in many movies, the hero is not a part of the mob, not carrying a torch toward the jailhouse. The hero is the lonely lawman who sits on the porch and won't let the mob in. That's what I think we are going to need in our next Attorney General. Mr. President, I yield the floor.